Good morning, everyone. Hear me okay? And good morning to those of you who may be watching this session via the live stream. And we want to say a special thank you to our friends at the State Justice Institute, to the funding they provide to NACM to be able to stream these sessions. We're glad you're here with us this morning, and I'm particularly glad to be sharing the podium and the stage with Judge Frierson and Judge Spillane, both of whom I've gotten to work with over the last several years on the task force, and both of whom are known not only to me and members of the task force, but they're known throughout the country and certainly in Texas as being real leaders in this area, both in terms of the contributions they've made to the task force and the contributions they're making back at home in their home state. We decided we'd cover the ground we want to cover this morning in three different phases or categories. Give you a little bit of background and context into what the task force is, how it came to be, what it's been doing, how we've been doing the work, and maybe most importantly, what it is we're delivering as products. So we'll start at the top. It was 4 years ago, almost exactly 4 years ago, when Michael Brown in Ferguson, Missouri was shot, and I think we all remember that the story surrounding, the events surrounding his shooting and the story surrounding that was front page news for quite a while. And it was in March of 2015 that the Department of Justice issued the report that you see here on the screen. Many of you may be familiar with it. Some of you may have read the report. And it was in the wake of that investigation and the release of not only this report, but the numerous other reports, media reports and other reports that followed, that the conversation really began in earnest around what the state of affairs was really in our state courts with regard to how courts were dealing with the imposition and enforcement of legal financial obligations, particularly as it related to people who were unable to pay. Of course, lots of people were paying attention to that commentary and the work that could flow from it, including the Conference of Chief Justices and the Conference of State Court Administrators. With regard to this report, one of the things, if you've not seen it, to note is that the report itself is a little over 100 pages. About 20% of the report is focused on practices of the municipal court in Ferguson, Missouri. And there were a couple of things that jump out in the report that the Department of Justice investigators highlighted and which people in the court community in one way or another, many people have really seized on. One of the things that was noted by the investigators was the municipal court in Ferguson was the practices that they were following were imposing barriers to the resolution of cases, which in many cases were intended to be resolved by litigants without coming to court. But because of court hours and perhaps insufficient notice on citations or insufficient notice on the website as to how these cases could be resolved, they were not often able to be resolved quickly. Investigators also found that the court was imposing unduly harsh penalties for people who were not paying or who were missing payments. They also noted that absent from the court's practices were any meaningful opportunities for defendants to articulate whether they had an ability to pay and to explore opportunities for satisfying the legal financial obligation in some way other than by paying it. The content of the report and of course the discussions that took place around it really provided an opportunity for those of us who work in the courts to examine our own practices and to consider to consider some hard truths around the way that we were conducting our own work in this area, and really provided an opportunity, if not an obligation, for judges and other court leaders to really step forward as leaders of reform. And I think it's safe to say at this point that there's little doubt on the basis of what we heard in the wake of Ferguson and what we've learned as a result, all the attention that's been paid to this topic, that this is indeed a time when reform is needed. Having said that, and notwithstanding the call to action that was responded to by many in our community, you can't really have a conversation about this reality without acknowledging, particularly at the municipal level, that there are fundamental challenges to reform. One of them, of course, is that municipalities rely greatly on revenue that's generated through the imposition of legal financial obligations, and no serious consideration or response to this challenge can ignore that. And without question, that has to be acknowledged and worked through. And the task force has done that, and we'll talk about that in a few minutes. One of the other challenges, of course, is that we know that people who work for municipal courts are often, not only often do they self-identify, but as a matter of fact, they are part of the executive branch and not the judicial branch. And that raises questions about transparency, about accountability, about communication, about setting priorities and following through on priorities. Anytime we study our own work and consider what courts are doing and how they might do better, I think those of us who've been in the business for a while, particularly in the area of research and evaluation, we know that local legal culture matters and probably matters more than anything else. And so we are not alone as judges and court administrators. We work with prosecutors and defenders and others, and the way we do our work, particularly we've been doing it for a long time, sometimes it's hard to dismantle an architecture that's been created over years, if not decades. And then, of course, the events in Ferguson and in other places are an important, perhaps the latest, but the latest in a series of things that confront us in our work to address issues that are uncomfortable and sometimes inconvenient, issues of class and issues of race. And I think it's also true to say that if we're having a serious discussion about this issue, about the challenges and about solutions, issues of how we do in that area, what training is needed in that area, we have to acknowledge that. And those concerns and that reality has been front and center in the minds of task force members as we've taken up our work. We don't have to look too far or too hard to get further justification and confirmation that these are issues worth thinking about. I think many of you who are in the audience, and probably lots of folks who are watching, are familiar with the work that the National Center does every year through their surveys. And we pulled out some key findings here from the 2015 and 2016 surveys. The 2015 survey was done after the events in Ferguson. 2016 was a follow-up to many of the questions that were asked in 2015. And you can see for yourself what emerged from this national survey that was conducted by the National Center. And in your hometown, in your home state, depending on how you're located, this may or may not speak to you. It may or may not be the reality that you confront when you go to work every day and you're partnering with your colleagues. This is a national survey, not to highlight any particular state, but in the states in which I've worked, I think these are fair statements of the reality that we're dealing with. The bottom bullet on each side was something that the folks who gathered the data and analyzed the data that was collected during the surveys held out as being important information for us all to acknowledge, because notwithstanding some of the real concerns that respondents had to how courts were doing work in this area, high marks both years were received in this area of procedural fairness. And so one of the takeaways I think from that is that we've got something to build on here. And if we are regarded by the people who come to us, whether willingly or not, that we do a good job in this area of procedural fairness, that's a good place on which to build reforms that may address some of these other issues, with which I think, based on survey findings like this, you could argue are pretty glaring. In Turning back to the work of the task force now, just a little bit about how we're organized, who makes it up, and how we've approached the work. It was in February 2016 that the Center sent out a press release announcing the creation of the task force. It was several months prior to that, probably, Judge Frierson, you were State Court Administrator of South Carolina, probably at the summer before this, in 2015, when I think at your annual meeting of CCJ and COSCA, discussion really began about what are we going to do about this. But in February 2016, the Joint Task Force, which is a joint task force of the Conference of Chief Justices and the Conference of State Court Administrators, was announced. And you can see on the right there the membership of the task force. In addition to this long list of members, there are liaisons from large grant-making entities, other partners from the university setting, and plenty of other people with deep research and practice experience who have all contributed to the work of the task force. And NACM was very fortunate to be invited to participate on the task force, and I have served for the last couple of years as NACM's representative to its work. 4 work groups were established to take it up, and each one of these on the top 3 are co-chaired by a Chief Justice and a State Court Administrator. Access to Justice and Fairness is Work Group 1, and that's the Chief Justice from New Jersey and the State Court Administrator from New Mexico. The second work group here is Chief Justice from Texas, State Court Administrator from California. Here we have the Chief Justice from Missouri, former Chief Justice from Missouri, and Judge Frierson, who was the former State Court Administrator in South Carolina. And along with Lori Dudgeon, who's the State Court Administrator in Kentucky, I've been co-chair of the Resource Center. We were all given charges by the task force and set about our work shortly after the first meeting. And one of the very first things that was done by the task force was to do a survey that went out through each state's State Court Administrator just to gather information about what the state of affairs is with regard to, I'm backing up a slide here, with regard to key activities in these 3 areas. The information can be summarized generally according to these bullets that you have here. So one of the things, and this was something, and I don't think I'm speaking for myself here, this was something that was really surprising to me and I think to others, is that the authority and the practice for creating or disbanding local courts, courts of limited jurisdiction, varies greatly and operates pursuant to very different levels of authority and formality in states around the country. There's a lot that we don't know. And in some states, the Supreme Court, the state Supreme Court and the state office of the administrator's office may not know when a court is created and may not know when a court is disbanded. The second bullet touches on something that I think we all know well and has been the topic of lots of commentary over the last several years. And that is that courts are indeed a revenue generator for lots of different things. And there's been litigation on that in the states, and that's been going on for a number of years. The standard as to what constitutes a proper cost or fee and what is not constitutional and may constitute a tax can differ from state to state, but it's hard to deny that this is a reality that we're facing. We talked before about how in municipal courts, I was talking to a court administrator from a municipality in Texas just the other day, and she doesn't report to her judge, she reports to the assistant city manager. That's not an uncommon state of affairs. And we know that judges in these jurisdictions are, generally speaking, are appointed and probably have their performance evaluated by people within city government. And that's an issue as we're dealing with these issues that were raised in the survey and that the task force is taking up. It's a reality we've got to deal with. In some jurisdictions, in Texas, for example, in some states, municipal courts, courts of limited jurisdictions are not always courts of record. We have, not only in my state, I think in lots of states, a high degree of variation with regard to the quantity and the quality of data that are collected that allow us to quantify the work of courts and to evaluate how they're doing. There's lots of holes here. The authority for and legality of financial obligations is an issue that is being litigated and is in need of ongoing study. And then the way our courts and court-affiliated partners manage collections practices is something that varies greatly from jurisdiction to jurisdiction. So these were the kinds of things that were animating discussion and orienting work of all of the work groups and have been for the last several years. Okay, we're shifting our focus now to deliverables and resources from the several work groups. It was in February 2017, about a year after the task force was announced, that we started generating our deliverables, and they are all available on the National Center's website. And if you've not seen it, it's worth checking out. It's ncsc.org/fines-fees. And what you'll find there is reports, studies, resources within several different categories here. We've done a little picking and choosing of things that we wanted to highlight for you all today, but there's much more on the website than we're going to be able to cover here this morning. These are the things we want to talk about. I'm going to talk about the first several things, and then the judges will talk about some of the things that they work specifically on. One of the things that we're really proud of, and we've gotten a lot of great feedback on, I should mention that the folks at the National Center have told us that this, the fines and fees space on their website, they call it a microsite, is one of the most frequently visited pages on the National Center site. And one of the things in particular that has people going there and coming back is the interactive state map. And so if you click on the map, you'll get a map of all the states, and we've done some screenshots here that we want to talk to you about. But the states are, this is all information that is maintained by the National Center staff, and it's on the Tableau platform, so you can click on a state and get information about what's going on there in a couple of different categories. And I just wanted to summarize some of those for you. One of those areas is in the area of bail and pretrial tools. So 17 of the 50 states have reported to the task force, to the center, that they're doing work in this area. So if I wanted to get information about what's going on in Texas, I could click on Texas and I would be given a list of things that are happening there, and they're all hyperlinked, and so you can go out and look at those materials. Same is true for all of the states. This information is current as of about 6 weeks ago, so these numbers could be a little bit higher. The second category is in the area of fines and fees tools. 27 states are reporting that they are busy in this area and have developed resources for use. And if you're in a state that doesn't have any shading on here and you're wondering why, or you think something should be there, talk to us afterwards, and we'll make sure we connect you with folks who can make sure that your information is there. The third of the 6 categories is litigation. 24 states have reported that there is litigation in a jurisdiction in their state dealing with some aspect of fines, fees, collections, or bail practices. Reports and studies have been done in the majority of the states. Statutes and rules have been amended, established in likewise a majority of the states. The takeaway here, there's a way that you can look at the country as a whole, and I think it's just 1 or 2 states where nothing is being reported as happening. So the takeaway here is that I was reading something several months ago about bail reform, and the author of this particular article made the statement that bail reform is having a moment, which I think is true in many of our states. There's a lot of momentum behind this, and that moment feels like there's a lot of space right now for there to be serious thinking and serious work done, not only in the area of bail reform, but in these other areas as well. And there's little to suggest, at least in the short term, that these bars aren't going to continue to move out. I'm not so sure that the litigation numbers we have on the state maps are completely up to date, because it doesn't seem that a week goes by where you're not reading about litigation that's been filed somewhere. So it may be that as we speak, activity in this area has achieved past the 50% mark. So for those of you who aren't busy in this work, know that there are many people, many of your colleagues who likely are busy in this work, And for those of you who have some responsibility in some aspect of this, you've got others in the States who are likewise quite busy. And so if you're not familiar with the website, I'd suggest going there and going to the map in particular and seeing what's happening, clicking on some of those resources. Just a couple of months ago, the task force released its principles on fines, fees, and bail practices. All of the members of the task force and its several subcommittees had input on these, and you can see here that there are 34 principles that fall into these several categories, and these are taken individually in some cases, and certainly as a whole. These are very bold statements about how our courts should be structured, how they should be run, and how they should be evaluated in the area of collections and bail practices. This is about a 4-page document. It's not terribly long. If you're not familiar with it, it's available for you to use as a reference, as a resource, and as guidance, if you like, in establishing rules or amending rules. One of the first things the task force came out with was a bench card for judges, instructing them, or not really instructing, but as a point of reference about the kinds of inquiries that judges should make when imposing and collecting legal financial obligations. The content here is taken from the U.S. Supreme Court decision Bearden versus Georgia, and is built around these key principles here, that the failure to, that prior to imprisoning someone for inability to pay, the court must find that the failure to pay was not due to an inability to pay, but willful or due to failure to make bona fide efforts to pay. And you can read for yourself, although this is perhaps kind of small. The second bullet here referring to alternatives. This is a 2-page document. We've gotten great feedback on this, and we believe it's met a need based on the feedback that we're getting. Again, it's on the website. One of the work groups took it on itself to develop a toolkit based on practical experiences that several of the states had to bail reform. Texas was one of those states, and I just wanted to share with you a couple of the lessons learned from the case studies from the several states. There's no doubt that one of the secrets to successful reform in this area of bail reform is related to strong leadership on the part of the chief judge and the state court administrator. The role of task forces, committees, commissions was also something that emerged as being influential in being able to make progress in this area. The ability to support, to learn about, and to export local innovations that are happening. In a state like Texas, this is particularly important, A, because we're not unified, and B, because we're really big. I guess C, because we know that jurisdictions are active in this area, but local innovations are also something worth tracking and supporting. Political support on both sides of the aisle. I think those of you who are following the bail reform issue know that we've got people from the right, from the left, all calling for reform and in agreement with regard to significant areas about what that reform might look like. And of course, without question, lawsuits are one of the things that are generating interest in and some urgency around reform. It wasn't, I don't have a specific slide for it, but it was on the list of things we wanted to talk about just briefly before, and that is the National Center has updated its Court Tools Measure 7 dealing with collection of legal financial obligations. And just by show of hands, is there anyone in attendance here who's administered the new Court Tools Measure 7? Well, it was, some of you may know that previously the original Measure 7, it's now 7A, B, and C, but previously it was one measure, and it was really looking at the amount of the initial legal financial obligation that was collected within a specific amount of time. That's clearly something, if you're running a collections program, that's clearly something you want to measure and you need to be able to measure. But what the center did was add 2 features to that. So while that measure remains, 2 other measures were added. One is a survey that's to be administered to people who come to court because they've had a legal financial obligation to impose to find out what their experience was, whether they understood why they were there, whether they were able to conduct all of their business while they were there, whether they understood what was supposed to happen next, touching on some of the procedural fairness things that we referred to earlier that we get high marks for, whether they were informed about any options, alternative options available for them to satisfy the obligation. And then the third one is designed to be a self-assessment instrument that judges and others who work in the courts would take and allow them to rank the importance of certain best practice features of collections programs, rank how they were doing, rank these things in terms of their importance, and rank how they were doing. And the idea there would be that not only would judges take it, but staff would take it, and it would serve as an opportunity to see whether people who work in the same jurisdiction are on the same page or are on different pages with regard to their performance relative to best practice. With that, I'm going to turn it over to Judge Friersohn, who will talk about a couple of things that she's been actively involved in her work group.
Okay. Before discussing some of the resources that have been produced through the task force, I'll share a short video of the Court Hack Hackathon, and it was held in April 2017. Court Hack is an initiative by the National Center for State Courts and Hacker Nest. And for those who are unfamiliar with what a hackathon is, a hackathon provides a mechanism for innovative businesses to emerge, and it has become the most practical, merit-based, and efficient way of vetting new ideas into implementation. Our courts have much catching up to do to close the ever-widening gap, digital gap that is, and technologies developed in the past decades have completely revolutionized the way we interact with the information in our legal system. Although times have changed, many aspects of our court systems have not. One of the challenges at the hackathon was to develop a court technology opportunity. In particular, court users need a convenient way to make their case, and courts need an efficient way to determine a person's ability to pay court fines and fees. And I'm going to show this video, which is only about 3 minutes, but it'll give you an idea of the work that was done there.
This is a great event because it gives us a marvelous opportunity to have people come in, look at the problems that the courts have, propose solutions without spending 6 months or a year on a solution that may or may not work well for the court.
The challenge that I have has to do with fines, fees, and costs. And I think what they really wanted to get at was ability to pay.
And there's really not a good way to determine somebody's ability to pay or even at what level they could pay.
Just the impact on people's lives if they go to jail for failing to pay, and if a judge doesn't hold ability to pay hearings. And the person, when she came to court in my example, didn't know what to tell the judge, and she ended up in jail, lost her job, was at risk of losing her family's housing, to say nothing of her self-esteem and her concern for her kids.
There are 5 teams that are all kind of approaching the same issue, working on the fines and fees challenge. That we're really focusing on the user experience, making it very easy for them to interact with our app, to quickly understand what their rights are when it comes to dealing with the court.
We're using the smartphone camera to actually scan in documents that they can provide as evidence of their income to better explain to the judge, requesting either a waiver of fees or reduction of fees so that they can have that interaction with the judge or the courts that they don't have now.
We are coming up with an online cloud-based app which, if the defendant can't pay the fine, the judge can review the information and also review any documentation that was submitted along with the request and approve or give alternative sanctions as opposed to the fees.
There's a big national project going on right now around abuses with fines and fees that come out of courts and law enforcement agencies and the impacts that has on low-income people. And so there are several projects that really are centered about solving those abuses. In addition to that, there are lots of problems around the inaccessibility of the courts because the processes are too hard to understand and the jargon and so forth. Several of the projects attempt to kind of mitigate those problems and make the courts more accessible.
The winners bring great application, I think, to helping people, again, as we talked about, navigating some of the fines and fees. there was a great utilization, I thought, of algorithms and artificial intelligence as well, which is a growing movement, as you understand, that can help our citizens as well. So not only are you bringing the ease of use to the litigants who are coming into our court system, but we're also bringing analytics for the court system to measure and manage their success as well.
But I'll tell you that the grand prize winner created an e-bench card, which is an electronic app to allow defendants to present their inability to pay their legal financial obligations to a judicial officer and to get alternative options to their obligations. I was going to say, as you can see, it's ever more important to encourage the development of innovative technological solutions to assist courts in assuring fairness and access. But I'm going to talk about the Model Code of Conduct, and this is one of the resources that Scott mentioned earlier. It's not currently on the website, but it will be on the website hopefully after August. But I would really suggest that you all take a look at it. It may be something that you want to use. But the Model Code of Conduct is for those who serve courts of limited jurisdiction, and it was developed for the employees in those courts who hold highly visible positions of trust. And given that the limited jurisdiction courts, as we all know, that those are the front line of our courts, and that's where most of the public, that's where they see people. They come to our limited jurisdictions, and that's where they have their encounters with the courts, and they develop their impressions and their opinions of the court and the justice system. And we felt, because of that, the code of conduct for that level is very important. And this code of conduct it keeps in mind that our business, our court business, we want to run our business in a manner that favorably reflects the values, the ideals consistent with the fundamental values of the judicial system. And these values include fairness, accessibility, accountability, effectiveness, responsiveness, and independence. And we developed 10 codes of conduct, and I should give credit, I believe, I want to say it's Minnesota, but I think we need to give credit because they were the ones who actually created a code of conduct, and we use that as a guide in developing one that we recommend or as a model for other courts. But the 10 canons of the Model Code of Conduct address: 1, impropriety or the appearance of impropriety; abuse of position; impartiality; proper use of public resources; duty to disclose; confidentiality and discretion; non-discrimination; political activity; duty to serve; and competency. And with all of these canons, it is a way of making sure that the employees are mindful of their roles and their responsibilities. And I was in a workshop earlier this morning during this conference, and it was on mindful kindness. And I thought that mindful kindness really plays into the code of conduct because it reminds an employee, well, first, when you're hired, you're given this code of conduct, they have to sign it and acknowledge it, and that acknowledgement of receipt states that they understand the code of conduct. And as a court employee, they agree to support the contents of the United States and their state's constitution, and they agree to faithfully discharge their duties of their office. So it kind of makes sure that here are the ideals that they should be living up to, and they've agreed, they've been presented what they're supposed to do, or what conduct they should exhibit. And if they don't, then as a manager or whatever, you have the opportunity to say that, use that as a way of holding them accountable. And so for those jurisdictions that do not have a code of conduct, I would really suggest that you take a look at it and consider implementing it at that time. There are many courts that, well, not many, but there are some jurisdictions that may not know all of the courts within their state court jurisdiction. Thank you. And so in all of those states, the state's highest court, the Chief Justice, the court administrator, they should be aware of all of the courts that are operating within their state, but they may not be aware of courts of general jurisdiction as well as courts of limited jurisdiction, including municipal courts, county courts, traffic courts, mayor courts, village courts, justices of the peace, and similar entities, and to assure that the state's highest ranking judicial officer and the state court administrator are both kept apprised on a regular basis of every court operating within the state's borders with the authority, and this is what's important, if those courts have the authority to levy fines, assess fees, or impose sanctions, or impose incarceration, you should know about those. And any court that has that ability should be covered by the Model Act. And states that have that authority, some states may already have the authority where courts are not created without the highest court being involved. But if you don't have that authority, then this act was created as a model to provide to your legislatures to create such an act. And along with this act, we developed the registration form, and the form was developed to be used in conjunction with the act or independently. If you already have the authority to know what courts exist, you may still want to provide this information to all of those courts to make sure that you have the details as it relates to those courts. But the purpose is to assure that the judicial branch is kept up to date on every court operating within the state's borders with the authority to levy fines, assess fees, or impose incarceration. And now I'm going to turn it over to Judge Spillane, who's going to talk about court curriculum. Thank you.
Thank you, Judge.
You're welcome.
And I didn't provide any slides, so we don't have to worry about that. I don't know if maybe I should buy a lottery ticket today or so. Part of the reason I wanted to participate in the task force was to really work on practical reform, and really reform's not going to occur if it doesn't go from a national task force to the people in the field. And so one area where I worked quite a bit on was the curriculum. And I'm going to go through very briefly over the curriculum, because the curriculum provides a day and a half to 2 days of instruction to the municipal courts that we want to reach, and the magistrates who are involved with either fines and fees or bail reform. The first part of our curriculum is basic principles. As Scott mentioned, when we looked at courts, it's very hard to figure out where these courts are, and a lot of states don't. And they even have kind of the, somewhat ridiculous in some states that they're part of the executive branch, which again, constitutionally, how can a judge be or a court be part of the executive branch? If you have an answer to that, let me know, because I haven't figured it out, and people smarter than me haven't figured that out. So we talk about principles, basic principles of court, because overall a lot of the problems occurred with fines and fees and bail reform because there isn't a separation of powers. The second thing that we're doing with the curriculum, and we're kind of breaking this in terms of classes, is an overview of the history, and you've just heard a little bit of the history of how we got here. Obviously, Ferguson, the focus of the Justice Department on the Ferguson Municipal Court kind of got us there, but we have all sorts of things right now, especially with bail reform. Georgia, it's occurring. You can go to states, Washington, D.C., it's putting out a lot of bail bondsmen out of business. It really is, there's a whole change in the outlook. And I think having the historical framework on this is important for any curriculum. The next, and talking about our overall principles, which I'll hit as I go through the different topics. Finally, ethics. And this is the third of a preface to what any curriculum should be. One of the things that we've seen in terms of ethical problems with municipal courts and magistrates is that what is, conflict of interest. You have in many states people who are a judge, and then in the other city they're the prosecutor, and then in the other city they're the defense attorney. And that happened, to some people that's, oh my God, I can't believe that, but I mean, that occurs. And it occurs for a reason. States are big, finding people who can do all of this, who are interested in doing this, is difficult. But there's obvious, as we saw with Ferguson, that was occurring. There are obviously ethical implications to that. There's also a lot of non-attorney versus attorney judges. You have some states where every judge has to be an attorney. You have many states where the people who are on the ground doing this are non-attorney. And so what are the implications of that? Then we get to the nuts and bolts, bail and pretrial incarceration. The model, just in brief, for dealing with bail has been a risk assessment. We've gone, and really like Ferguson, it's taking a practical look. If you look at your local jail and the people in the jail are with any sizable percentage in there for a misdemeanor, nonviolent misdemeanor, and they're indigent, and you see that, and that's the reason they're in jail versus what generally most reform efforts and most experts agree, jail, especially pretrial where people are legally innocent, that's there to stop people either who are a risk to a victim with a violent offense or someone who has shown a history of not showing up to court. But that's the point of jail, and we see in a lot of places, unfortunately, where that's not true. So talking about bail, and you can look to just our state, Texas, Harris County, and Dallas County, there's a number of lawsuits that are occurring right now. And there's a lot of bail reform legislation that's gone, New Jersey, a number of states. Our fifth class is right to counsel. This is a real tough area, especially with fines and fee type of punishment cases, because generally, since you're not facing jail time as a punishment, if you're indigent, you are not appointed counsel. We see states vary. However, we all know that if you don't pay your fine, you could end up in jail. So how can that be that you're not sentenced to jail, and yet a lot of people end up in jail who don't pay their fines? And so talking about what does right to counsel mean, and where is the Supreme Court on that, and what is it really? Is there really a difference between a commit to jail hearing when someone doesn't pay a fine and a sentencing hearing? Pro se defendants, I saw on the topics, maybe tomorrow I believe, but most of these courts are dealing with people who are representing themselves, and those provide a lot of unique challenges. The most violent people in court are pro se defendants or family law cases. And so these courts are dealing with people who often, it could be a parking ticket. In fact, people probably get more upset with parking than anything else in the criminal system, it seems, our civil system. And how do you deal with that? And what are the unique, especially with pleas and that are voluntary? They're supposed to be voluntary and knowingly done, but how does that work with pro se defendants? The seventh class is on the real nuts and the real guts of what we're dealing with, ability to pay hearings, and the idea that when someone pleads guilty or no contest or found guilty or no contest, they have a right then, if they don't pay immediately, to have an ability to pay hearing. That simple right that we got passed in Texas, but that simple idea solves a lot of problems versus someone's in jail and then the judge is learning they're homeless or other things. Just that simple change, but it's very important in terms of teaching, and goes back to current law. This is a lot of the things in Ferguson the law was not new. 8, alternative sanctions, and this is a whole area I walked in at the end when the mindfulness discussion, meditation, all these unique out-of-the-box thoughts about how to think about courts. Well, alternative sanctions are working and have worked and often are much better than jail for these cases. We also have discovered the use of waiver, the ability to waive cases where someone's indigent and the alternative sanction they're not able to do. Someone goes off to the penitentiary. The waiver solves a lot of problems with these cases, and unfortunately now there's only a few states that have employed that. The ninth class, direct and indirect collateral consequences. There are so many consequences to this problem in we're seeing the number one with no driver's license. I mean, we have been taking driver's license away left and right here in an effort, supposedly, we called in Texas to put criminals off the road. Instead, it made people criminals on the road. And we're seeing many states reevaluating and looking at those collateral consequences. The 10th is judicial demeanor. The 11th is access to justice. You know, what Rosalyn just talked about, more and more courts need, in order to have access, it's not just having an open courtroom and a courthouse there. It's people being able to do things online, tools that one can use online. The hackathon is a great idea and an example of that. And finally, final minute of my presentation on curriculum is accepting change. I've seen a lot of change myself as a municipal court judge. We've all seen it, and we've actually seen good results. Just like bail reform, so far, knock on wood, in the states that have adopted it, they've seen more people going to court. And you know, when you're thinking about risk assessments and whether people are getting to court, you actually find good results. We've seen that when you eliminate jail as something out there that people are used to for people who don't pay fines, you actually see people pay more fine, or you know, when it's more the focus, they'll either pay or they'll do the alternative sanctions, and you don't have the jail as kind of just this thing that people all want, including defendants a lot of times, because you know, they sit in jail, they get credit. That's not what it was all about. And so accepting change is important, is the final group from our curriculum. Thanks.
Wanted to leave time for questions.
My question is, what are the alternative sanctions that you all are employing?
I can take the number one, and that we've all been used to in courts, is community service. That's been kind of the common at a nonprofit or government. Texas now has expanded what community service is because sometimes bettering the defendant is helping society. So it can include GED instruction, it can include drug treatment, it can include tutoring. It can, also alternative sanctions play a key role, I think, with the waiver process, where you know, we don't want our cases lasting 5 years. So if someone does something, maybe pay or do community service or do the mentoring, hopefully within a year, the rest can be waived. So, but the major still that we have as alternative sanctions tend to be community service. We're learning a lot from juveniles, though. Juveniles in general are deemed to be indigent, and teen court is a very powerful thing that we use, at least in Texas, as an alternative sanction.
I wanted to ask you about warrants.
Sure.
If people don't appear for the hearing on bail, what standards are you implementing before judges issue warrants to get people arrested for crimes that may well be indigent and not able to pay?
We now have in Texas that if someone does not appear in court, that we have to call and or send them a notice. They have a right to a hearing. They get a new due date. They have a right to a hearing. And if they don't appear at that hearing or show cause, then only then can a warrant go out for a failure to appear. And even on that, at least with fine-only cases, you cannot have a bond. You have to release the person. So that's the way Texas has gone with that. There are a lot of states that will put hold on licenses and other things to avoid the whole warrant. But we still have, in Texas at least, you can be arrested eventually, but you cannot be forced to post a bond, and therefore, so you're going to be out of jail within a day, and you do have a right to hearing. And we've legislated good practices, which a lot of courts do, of calling. You know, the most common thing that people have, I'm in a college town, but this is the most common thing associated with people now. So hopefully the police get the cell phone number and reaching people that way, because people move around all the time. And so using tactics, trying to avoid. We also do warrant amnesties, which we tell if you come here, we'll waive the warrant. We also have a rule in Texas, and it's if you go to court and you're in warrant, but you come to court, you cannot be arrested. So it's a safe harbor. And that's worked wonders. And, you know, that's what judges want to do. You know, most people who fail to appear, they didn't make a plea. They can solve that by showing up, make their plea. It's not super complicated once they go there. So Texas, I was kind of surprised, but they legislated a safe harbor. So that's another thing. So we're trying, because why people don't appear is multifaceted, and it is tough for a court, because a court can't go forward. If someone doesn't show up, we could have wonderful hackathon, you know, great things, and if they don't show up, we're kind of stalled, as I know court administrators well realize as well.
I was curious if you had any other examples besides the ability to create a calculator where you're looking at technology that can be applied to something.
I was going to say, there is and I can't remember the exact name, but there was a grant that was given, and there's work being done in, I believe, 5 states, and that's part of the purpose to actually come up with some innovative ideas and that can be used in other states. And I know Washington State is one, Louisiana.
California, Louisiana, Missouri, Texas, and Washington.
But that very question is what is being worked on to try to figure out what things can be done, whether it's developing mobile apps for ways to contact people to remind them of their hearings, apps where people can go in and actually, as opposed to going to court, just go ahead and pay their fine or communicate with the court electronically. But those solutions are being worked on now.
And there's a lot being done in terms of bail with risk assessment, because again, that's the problem. It's easy to say you have to do a risk assessment to the judge in 24 hours, but most counties aren't, unlike large cities, maybe Atlanta has a resource, have pretrial resources. And so there are a number of the Arnold Foundation is the main one I can think of, but there are a lot of risk assessment tools being developed as well for bail.
We have about a minute left if there's any other questions. If not, thank you very much for your attendance.